We're going to now focus on trauma-informed preparation for legal proceedings. I'll introduce myself first and then invite my co-panelists to introduce themselves. My name is Morgan Weibel, and I am the Director of Client Advocacy Legal Services at Tahre. And what that long title means is it's my job to make sure that our lawyers and legal advocates are prepared and equipped with the resources that they need to be able to represent our clients. I'm an immigration attorney by trade, and I've been doing this work for 2 decades and with Tahre for about 15 years. I'll now invite my co-panelist, Fiamma, to introduce herself.
Thank you, Morgan. Hopefully everybody can hear me okay. My name is Fiamma Stevens, and I am a social services program manager at the Tahare Justice Center. I have been at Tahare for over 4 years now, and I have the privilege of working in our Maryland office, managing our case management program for clients. And I'm really excited to get to chat with you all about some important considerations today. I will pass it to Dulce.
Thank you, Fiamma. Hi, everyone. My name is Dulce Jacobo. I am a senior social service advocate for Tahari Justice Center, and I'm in the Atlanta office. I've been with the organization for a little over 4 years as well. And so, yeah, I'm looking forward to continuing this discussion with you all.
So we want to begin by establishing trust, and we do that by thoroughly explaining what the legal setting is going to be like. We can set the tone by explaining the scope of representation, confidentiality, what that means, attorney-client privilege, in enough detail and enough plain language that the client can understand all of those concepts. And we also want to be sure that we take the time to explain what to expect from every single stage of the proceedings. This might look like at the beginning of the hearing, the judge and the other attorney and I are going to be talking about some last issues. Then the judge is going to talk with the interpreter, and you can describe the process of what it looks like for the judge to swear in the interpreter. And then next, the judge will ask you to swear to the contents of your application. And this is where you're going to want to clarify and carefully go into every detail. So you can physically move through the motions and explain the judge will ask you to raise your right hand, and they will either ask you to repeat what they say or they may ask you to answer a question. Going through it in that kind of detail is going to allow the client to really understand and imagine what the setting is going to feel like. The more details you use and the more responsive they are to the different ways that we learn. You remember Pyle mentioned before that, some of us are audio learners, others of us are visual learners. The better prepared that your client is going to feel, and then the less stressful the experience is going to be overall. So when we talk about using plain language, we want to just scrub all that we're explaining of any legalese or any technical legal language. Think about how you might explain this to your grandmother or a neighbor or someone that you run into on the street. You also want to use visual aids whenever and wherever possible. So you might pull up pictures of the courtroom. If you don't have pictures available of that courtroom, you might draw a picture of the courtroom or map it out for the client, describing where everyone sits within the courtroom, right? Imagine the client goes in and sits down at the government's table. That can be an embarrassing scenario or situation. So, what you're doing is giving them the landscape of the courtroom, describing where they'll be, where other players in the courtroom will be, so that they can go in feeling more knowing and comfortable with the environment and the situation. You will also want to describe who is in the room and what their role is. Even better is if you can check ahead of time and know the judge that you're appearing before, or the trial attorney that is assigned to your case, or the interviewer, the officer that's going to conduct the interview, so that you can help explain their specific approach to the client. And then there's less chance for unexpected experiences in that trial or in that interview. I'm going to invite my colleague Dulce to also share here.
Thank you, Morgan. What I wanted to add here is sort of kind of revisit the trauma-informed principles, because to me, this is an example of when and how it could be applied into practice. And revisiting those, principles are safety, trust, collaboration, empowerment, peer support, and considerations of the cultural, historical, and gender issues that have shaped these people when they walked into the doors. Um, think about how you provide safety for the people that you work with in the work that you do. Also think about how you have gained trust with the people that you have worked with. And thinking about these things, I want to share a story that was told to me of a client here at Tahare. And this happened before I came into the organization. This client was scheduled to have their intake. So that means the pre-screening had already been done. She showed up to our office, took time out of her day to not work so that she could come into the office, took a taxi. And so there's all these things that they have to do on their end to make it to our office. When she arrived, um, she called our office and was in emotional distress. Um, because our office used to be in the 19th floor of a building, and that meant she either had to go up 19 floors of stairs or take the elevator. And what we were not considering and were not aware of was that her traumatic experience had happened in an elevator. And so, the team quickly acted on this. They met her downstairs. First and foremost was the, the work for everyone to help the client regulate her emotions, validate what she was going through, and then find a safe space where they could do this for her. To be quite honest, I don't think the intake was done in that day because of the emotional distress that this person had due to the re-traumatization being triggered by an elevator. These are things that we usually don't think about if you haven't had trauma in specific places, but these are things to consider. And so, on the team's side of it, I think it taught us to be more thorough with the questions that we do, and be more thorough with the considerations that we have when we schedule an intake with the client, to consider the space that we're meeting them in, the time, the possible triggers that might happen on the way to and in the meeting. And at the end of it all, on the positive side of things, it did provide for an opportunity for the team to establish the beginning of safety and trust. They validated her emotions. They supported her. They did not minimize anything that happened that day. And so, to they continue to reinforce the trauma-informed principles through practicing a lot of the things that they did on that day consistently with repetition and, transparency, as Morgan mentioned, being as detailed as possible, explaining to them the legal setting and just the overall process of things from the very little details of the first appointment all the way to the end of whatever the process might look like.
Okay, so now we're going to look at practical and logistical preparations. And as we do this, we need to remember that uncertainty fuels anxiety. So the more we do to prepare ahead, the more we can hopefully eliminate uncertainty and in turn decrease some of the anxiety that most clients are feeling heading into an interview or a hearing. Now, keep in mind that these are really high stakes situations. The former president of the National Immigration Judges Association, Judge Marks, described immigration court perfectly in saying it's like a traffic court with the consequences of a death penalty case. So it's high volume and fast paced, but the consequences of someone with a valid case losing and being deported are life and death. And clients know that better than any of us in the courtroom. So when we say it's natural for them to feel anxious in entering that courtroom, it's because in many instances their lives and the lives of their loved ones depend upon what happens inside that courtroom or during that interview. So, if there is anything we can do to take some of the stress out of their day and just getting into the courtroom or into the interview room, it's well worth our investment of time and effort. It's important to confirm with clients their transportation plans and then walk them through from the very front door of that building all the way through security and into the courtroom, what it's going to look like and what is going to be asked of them. So, for example, if they need to remove their belt or their shoes to get through a metal detector device, share that with them ahead of time. This is actually another point of empowerment, where with that knowledge, a client might choose to wear something different to avoid discomfort in navigating having to remove a belt, for example. Be on top of it as well. Go to the building the week before, watch the local listservs from other lawyers to be aware of when changes are happening. If knowing that there is road construction near the court, so that you could warn a client to leave earlier in order to avoid arriving late can avoid stress, or even worse, in the immigration court context, to avoid an order from the judge ordering them removed in absentia, or because the client fails to appear on time, it's well worth it to do that. Also, at this point in working with your client, you know them well and can help anticipate some of their triggers. So, if your client experienced abuse at the hands of law enforcement, it's important to share with them that at the court there are men and women in law enforcement uniforms and explain their role and purpose and what types of interactions the client can expect having with them so that they can mentally and emotionally prepare for those interactions. Like Dulce's example, if you were going to court with this client and you knew it was up several floors or flights of stairs and there was an elevator, you'd want to talk that through ahead of time so that they knew. It's also important to discuss courtroom norms and expectations. I often share with clients that to demonstrate our respect for the process and the judge, we dress up like we would for a job interview or going to church or to a formal family celebration. It is also equally important to point out that cultural or traditional attire is acceptable in courtrooms. We want our clients to feel as comfortable as possible going into this high stakes environment. And imagine how you would feel if you unknowingly showed up to an event in very different attire than everyone else in the room. Or imagine a client foregoing traditional attire, which is their norm, out of fear that it would negatively impact their case. Let's take the guessing work out of it for our clients and relay as much information as possible so that they can prepare. And going back to the point that we all learn or absorb information differently, it can be helpful for some clients to have certain pieces of information written down for them so they don't have to remember a million logistical points. Now, of course, if you're working with a pre-literate client, you're not going to write things down in the same way. You'll need to adapt to what works for them. So, are you able to print out a series of graphics or images to help them remember the same information? These are all things that can help take some of that stress out of what is inevitably going to be a very stressful situation. Let me now invite Fayama to share some more.
I really like, us naming here this portion that uncertainty fuels anxiety, because to some extent we can all probably relate to that, right? I know if I'm invited somewhere absolutely new that I've never been before, one of my first questions is, what does the parking look like? Right? Because it fuels that anxiety to not know what that looks like. Um, so having that knowledge helps settle me if I can go into the situation with a little bit more information. Um, so I definitely want to help us kind of have a little bit of correlation, something that maybe we can also relate to in the way that Morgan is presenting, the way clients may, experience going into a courtroom. I also want to name, right, that this is a lot of logistical information that we are suggesting you all break down, and naming that breaking it down as far in advance as you possibly can is going to be the most helpful. Do not wait as best as you can until the night before the hearing to break this information down for your client. Start a few weeks ahead giving this information so that your client has time to digest it. You can make different plans as needed, and you can really talk through creative ways to remove those barriers as needed. If you have a client, for example, who lives in a rural setting, thinking through, what does transportation look like for you? Do you have the ability in your organization to offer transportation for the client in this setting? Or do we need to creatively think with the client about different transportation options? If there is a train or a bus that they can take, is that something that's comfortable for them? Do they know how to take that public transit if that is the only option? Or do they need some time to learn how to do that and become comfortable with that process ahead of time? So, and similar to what Morgan already mentioned, right, being intentional in the way that you share this information with your clients, knowing the best way, as we have said, that your clients learn either writing, audio, visuals, and doing the best that you can to be able to break down that information for them. It is going to be the best way to set them up for success in that moment. I think will
Right.
remain on the slide we're on, correct?
Yeah, great. We'll spend a few minutes here talking about preparing for the direct and cross examinations because those can be a source of a lot of stress for our, clients and attorneys included. So, conducting mock interviews or examinations can give clients a preview of what to expect in the hearing, especially if they're going to testify through an interpreter. It is crucial that they practice using short answers and pauses to allow for accurate interpretation. It feels very different to testify through an interpreter. And the last thing we want is for something crucial to be misinterpreted because the client testifies too quickly and an interpreter misses an important piece of that information. So, doing mock or pretend direct examination can help clients practice open-ended storytelling as well. And it can help them avoid scripted or memorized answers and instead get used to responding to the question that is being asked of them. And by the way, one of the most important points of empowerment we can give our clients is to remind them that truth is the end goal in their testimony. So if they don't understand the question, even if it's one that you are asking them as their lawyer, they need to ask for clarification before they answer. Now, it can be near impossible for someone to feel comfortable asking a judge in a robe who is deciding their fate to rephrase a question. So you may have to have them practice it several times beforehand so that they're able to then do that in court. Because answering a question that they don't understand can lead to major issues for their credibility. Even just practicing giving answers into a microphone can be an important skill for a client who may never have used a microphone before. And if this avoids a judge repeatedly interrupting a client during testimony to repeat, speak into the microphone, that sort of constant critique can weigh on any of us. And we don't want our clients to feel like in the courtroom, they're uncomfortable or they're being critiqued constantly. And the way to avoid that is just to practice it beforehand so that they can get more comfortable with things that feel unnatural. So if the courtroom experience or the interview experience requires something unnatural, it's important that we practice that with them first. Equally important is to share with them how the courtroom procedures work. So let them know that interruptions, like objections, are to be expected. That doesn't mean that they have done anything wrong, right? I think it's easy for us to interpret an interruption where someone says objection as though the person talking did something wrong. But if they understand that it's just part of the court experience, that attorneys are going to be interrupting and making objections, that can feel more comfortable or at least be something that they anticipate. So practicing that can be really important. There is nothing harder than to remember where you were in your story or order of events. If you've been interrupted and then there's a whole 5-minute conversation back and forth between each of the attorneys in the room arguing about something, right? So it can be really essential to practice kind of the pacing of a hearing and a proceeding. And then on the issue of cross-examination, it's really important that we explain it within its context to our clients. Adversarial questioning can feel intimidating, intrusive, or even aggressive, especially for someone who has experienced trauma. It's not natural in our regular conversations to have someone go back over things that we've just said or to bring up statements we gave to someone else years ago and ask a lot of questions about them. And if that starts happening in a conversation, a normal response is to feel attacked. So we need to explain the why behind it to our clients. It's that the other attorney's job is to go back through your testimony and to test your consistency. And then we also need to explain that the point of cross-examination is not to attack a client personally. We know that there are, some trial attorneys out there that do make personal attacks against clients. And if that's what you have in your setting, it's important that the client be forewarned so that they can be expecting that behavior. And again, this is an important place to remind the client that they can and should ask for clarification if they don't understand a question. We should normalize that by saying something like, we all have to clarify or ask for clarification at times. Don't feel bad if you do that, and know that you have the right to do that. Let me now turn it over to Dulce to share some more on this.
Thank you, Morgan. I want to add to this and to something that Sarah mentioned earlier about how trauma affects the brain and how we store memories. It's important for us to get some information into the neurobiology of trauma because it helps us understand how it affects the basic functions of our brains. The first point that I want to make is about the codification and the storage of our memories, which we've talked about throughout the presentation. The hippocampus in our brain is the part that is in charge of coding the memories, the timestamps, and the emotions that are connected to specific memories. During extreme traumatic experiences, the hippocampus goes into overdrive and the tasks that it is assigned to do just become limited. So that means that the codification, the storage of memories, and the chronological order of things are not going to be, thorough as we might usually would want them to be. And so that means that the clients you work with will have fragmented memories or disorganized thoughts. And so when you're asking them questions like who, what, when, where, how, why, it's important to consider how literally at the biological level they might not be able to respond. The other part of it too is, as Morgan mentioned, when clients walk into the court, there's going to be anxiety, there's going to be fears. And so another important part to remember is the function of our limbic brain, which is our emotional brain. This is where we have the fear circuit. When the fear circuit is under stress, especially in traumatic experiences, it also goes into overdrive. And so this means that it also affects the way that memories are coded. However, sorry. So one point with that is how memories, whatever memories the survivors might have, will be connected and associated with emotions. So the biggest suggestion as you're trying to prepare them is to focus on emotional narrative because this can open up access to more memories. So an example of a question of questions like this could be one that you shouldn't use is what happened after they tried to choke you. The after part of it is asking for a chronological order or a very specific path for the brain to retrieve information. So instead, ask what else do you remember after they tried to choke you? That opens up bigger paths, bigger memories that they might be able to retrieve from. They might remember a smell, a thing they saw, a feeling, something they felt physically. And so again, that opens up access to other memories and it can make it a little easier for you to prepare them for the courtroom. And so, I hope that this information about the neurobiology of the brain, coupled up with the principles of trauma-informed practice, can be useful as you're preparing to meet with your clients for direct and cross-examination. And I'll pass the next one to VM.
Okay, so now we've made it to after the hearing, and your client is likely stepping away from this experience very emotionally raw and vulnerable. And it's important for us to highlight that what your client needs in that moment is emotional safety before anything else, validation for the experience that they just went through matters more than the legal analysis that needs to happen. If you can, do your best to find a private space to debrief with your client and offer water before anything else, a place to sit, and a simple asking, "How are you feeling right now?" could really go a long way in that moment. Your client likely just expanded a lot of emotional effort in being present in this courtroom before these officials. And it's going to take a minute for the brain and body to come out of a likely fight or flight state. So please allow that time for your client to have a private, if possible, calm moment to be able to regulate again as much as possible. If you have practiced any techniques with clients as you have been preparing for hearings, um, such as breathing exercises, physical grounding techniques, this would be a great time to practice those to help your client re-regulate again after this intense experience. After allowing that space and really prioritizing your client's well-being, allowing them to lead that conversation into what they want to talk about. I have experienced clients who are like, "I don't know how I presented in there. Did I share my story well enough? Did I say this thing wrong? Or how do you think this went?" Allowing that to take precedence over the next things that you need to talk about because we want to honor what is top of mind and most pressing for our clients in that moment. As you hop into the legal analysis of what just transpired, doing your best to again break everything down for your client as best as possible, providing any timelines in simple language, providing it to them in writing if that is how they receive information best, and just giving them what next steps to expect, right? Again, we don't want to fuel the uncertainty. We want to take that away as much as possible with giving information. So, naming for our client, this is what we can expect after today. We can expect a decision in a month. We can expect a decision in X amount of time. It will come I will receive it via email. It will come through the mail, whatever that looks like, sharing that with your client to give them that information as best as you possibly can in that moment. I think Payal talked about this earlier in exploring setting up meetings with clients during a time when they might have supportive services available to them. So either before or after a therapy session. I think that would also be something to, during the logistics of talking about this hearing that's coming up, think through that as well. If your client is connected to supportive services, could they potentially schedule a therapy session for after this trial, this hearing, or the very next day? And renaming that for your client in this debrief. You have your therapy session with so and so tomorrow, right? That's really great. I'm sure that will be helpful for you to debrief what happened today. If there is no supportive system for, say, therapy for your client in that moment, offering those referrals and those resources could be really valuable in that moment as well. Perhaps even if it's not a quick way for a client to get into therapy services, most states and even county specific locations have crisis hotlines, warm lines, as we call them, where clients can call in to receive some limited mental health support when that is needed. So having that on hand as an advocate to pass on to a client in the post-hearing support could be really valuable, and we definitely encourage it.
So this last slide is just a kind of overview wrap up of what we've covered so far. Just a couple key points I'll highlight and then invite my co-presenters to share as well. It's important to remember that grounding techniques are not just useful outside the courtroom, but they're also critical inside the courtroom and during trials, right? So this might mean knowing that your client needs to put, a certain stress relief ball in their pocket or hold on to a smooth rock during the testimony. It could also mean in an interview setting where you're in a smaller room together in front of an officer, it might be harder at times for you to have the client ask for a break. Maybe you developed some sort of, signal with the client before you go in that if she clears her, voice 3 times or coughs 3 times, that's when you say, Officer, I need a bio break. Can we pause for a minute? There are lots of different ways that you can work out with your client an approach to integrate grounding into the interview and into the trial space. And we should be doing all of those with our trauma survivor clients. The other piece I'll highlight on this is that a lot of the work that we have to do as trauma informed lawyers begins before we even get to the courtroom, right? It's about trying to work with the opposing counsel to narrow the issues, trying to submit evidence that makes things clear so that the client doesn't have to re-testify to details of the trauma. And so make sure that we're really using all of the legal mechanisms in our toolkit to engage witnesses and evidence in a way that supports the overall holistic trauma approach to the case. Let me invite Dulce and Fayama in to share kind of any last thoughts here.
Thank you, Morgan. I mean, a lot of what has been said already, it has been, super important to provide that emotional support for our clients. Like Fiamma said, a specific place where you guys can talk about what happened, and more than anything, check in with them. If they have any support systems that they would like to have, or check in before or after, I think that is an important thing to also consider, right? If you need transportation for two people, if you want to make sure that that your client has time for a phone call after or before with whoever they want to check into, just taking inventory of what makes them feel supported, well, outside of us, outside of what we are able to provide.
And I think I will just name that this is a lot to take on, right? As advocates, I don't want to minimize that. That it is a lot easier on our end to just hand a client a piece of paper that says, this is when your hearing is at this address, at this date, be here at this time. That's a lot easier than walking through all of these logistics that we have named and all of these considerations. So I want to honor that as advocates, this is a larger load to carry, but reminders that it is so, so helpful for our survivors to be given this extra support and these extra guardrails to be able to help them engage as safely as possible in these proceedings. And that's the reason that they turn to us, right? Because there's that trust in us being able to understand and validate their experiences and walk alongside them in this way that we are honoring their needs. So I just wanted to name that. And I will pass it off to Addie.
Deep breath for all of us as we enter part 4. It's the last part of our institute today. And Miriam and I will cover ethical responsibilities in trauma-informed representation. We've covered ethics throughout today, but here is going to be the button, if you will, to wrap it all up together for all of our participants today.
And so, as we are looking into ethical considerations, attorneys may be tasked with assessing and mitigating risk, but also trying to have a game plan in the event if a client suddenly stops responding to all communications or they stop attending meetings. And also other situations where you may feel that the client may not be fully truthful, but also how we can develop trust with the client in navigating our own trauma responses. And so I want to go through the two model rules prior to us advancing to the next slide. But the model rules of professional conduct align pretty closely with the trauma-informed principles that we have talked about at length during this presentation. With Model Rule 1.3, it requires attorneys to act within reasonable diligence and promptness in representing clients. So, as we mentioned, acting diligently reinforces trauma-informed principles of trust and transparency and accountability. But as Adi had actually said earlier today, is also following through on commitments really strengthen that client's trust in the attorney-client relationship. The other model rule is Model Rule 1.4, which focuses on communication that further supports trust and relationship building. So, transparent communication really empowers clients with the knowledge to make an informed decision, the agency, voice, and autonomy as we have mentioned various amount of times throughout this presentation. The other thing about clear communication is that it promotes mutual, collaborative, and power sharing dynamic between the attorney and the client. So, this communication duties really help the attorney support the client's goals and desired outcomes for our legal matters. And so, what are our best practices when navigating our legal ethics through this trauma-informed lens? So, as we mentioned earlier, we talked about how we will, as attorneys, we would be faced with having a game plan in the event a client is not responding or has suddenly gone unresponsive to your messages. So, one of the best practices that you can do is within these first few meetings, asking the client and yourself creating a clear plan for maintaining contact. That plan can be a trusted person that the attorney can reach out if they lose contact with the client, but also be aware of maintaining attorney-client privilege, as well as making sure that you may need to obtain releases of information to communicate with the person the client identifies. It is also advisable that the client themselves talk to this identified person so they know their role should they be contacted by their attorney. There is a world where a client may choose not to provide any sort of person that they can be in contact with. It could be that they lack a safe option. It could also be that they are uncomfortable in disclosing that they have an attorney. And if our clients are newly arrived, they may not have that support system that a person may need to be able to identify. So, overall, regardless if the client selects or identifies someone, or if they choose not to elect someone, the attorney must respect the client's decision regardless. And the attorney must explain the possible consequences of losing contact. So they might be unable to fulfill their obligations under the retainer agreement. Slide. Oh, sorry, just kidding. Stay in this slide. Um, the other thing that you may want to do too is engage within your own resources internally or externally. So you might be tapping into a social service staff member or a mental health professional. And so, really making sure that you coordinate this support between the client and our services and making sure that they can help mitigate any sort of triggering memories and or staying engaged in their case. As my colleague Fiamma had mentioned earlier, that clients and the way trauma may manifest is through fight or flight. If a client, and this has happened actually not too long ago, if a client is triggered by a specific memory, they may become absent after a while. They realize that when they talk to you, they have to bring up really hard memories. And that might be a way in which a social service staff member or other mental health professional can help mitigate some of those circumstances and help set a good platform for us to help minimize the triggering response. And as always, it's important to make sure that as you're speaking to a mental health provider or a social service staff member, that we have the appropriate legal permission when communicating with any sort of information about the client. And there may be, if a client is unresponsive, there might the attorney may need to reach out to the client in multiple methods in the event that the client is no longer responsive. So, oftentimes that can be sending a letter to the client's address, but making sure that that conversation previously is stated that the client has identified that that address is a safe address to receive mail. Calling any known numbers at different times and on different days. But again, making sure that that is a safe number and that there are legal permission before communicating and or contacting phone numbers that may or may not belong to the client. Sending emails or text messages and or reaching out to the client's designated alternate contact if there's any. But again, remembering that if we're contacting anybody outside of the client themselves, that there is the attorney-client privilege being preserved. And sometimes, like we mentioned, that clients may not feel comfortable with sharing with others about the fact that they have an attorney or that they have a pending legal matter or if there's anything confidential. And as we always mentioned with VAWA funded organizations, that this does need to have a release of information before sharing information with anybody outside of the client. And so, if it is safe and appropriate and the client remains unresponsive, the attorneys may consider contacting other people like the in-house social service staff, a mental health professional, or any other relevant staff in the office. And the other resort is to see if, and should be done with utilizing peer support as well as your internal resources, is contacting law enforcement to conduct a wellness check. Oftentimes, when you are reaching out to your peer support and in-house resources, it is important that you all discuss the risk factors associated when sending out law enforcement to a client, only because it can really trigger the client as well. So we want to make sure that we have tried multiple ways to contacting clients when we are trying to make sure that they are in fact able to be contacted to achieve what is listed out on our retainer agreement. And I will now pass that off to Adi.
So we have been talking about a client who is not responding to our attempts to reach them. The part of the reason for that is that it happens to be one of the most common things to happen with clients, for a variety of reasons. So Miriam covered a variety of ways to attempt to reach the client, including making a plan before getting deeper into the representation. Um, but I want to bring us back to the diligence ethical rule for attorneys, which means that we need to be doing our due diligence to ensure that we are helping the client achieve their legal goals. Because I know that we think about what our um, liability risk is if we miss a deadline, if we don't do something, or if we do something without the client's input. So part of that includes preserving the client's legal interests to the best that we can. For instance, what can you file with the information that you have if the client is no longer responding or is no longer cooperating is no longer an active cooperating participant in the process? You might not be able to file something like an application or other documentation. Um, and that is a hard truth to come across. If you feel like you are reaching that point and you are trying to balance your ethical duties with your duties to the client and in your practice of being a trauma-informed lawyer, one of the best pieces of advice that we could give is to consult your jurisdiction's ethics bar for very specific advice on how to handle the situation. It could be that you just won't be able to file something for the client because you need the client's express confirmation that the contents of the filing are true and accurate, and you need their signature. For something like that, you might not be able to file it. In other circumstances, you might be able to request an extension of a filing deadline or to postpone a hearing. And here we're talking about that ethics rule of communications with the tribunal. So if there is a breakdown that happens in your communications, you might need to make such a request. And again, you're thinking about your duties of candor toward the tribunal and your duty of confidentiality to the client, both under legal ethics and under the VAWA rules, while also ensuring that the client's legal goals can still be met somehow. It's a huge balancing act. It's not easy. And there can be times where reasonable minds will disagree. And so that's why one of again, the biggest tips, best practices we can give is to make sure you're consulting your jurisdiction's ethics bar. And also think about ways in which you can thoughtfully inform the tribunal about the impacts of trauma on the survivor, how that has influenced participation, how that has influenced the work product. Again, while balancing confidentiality and while balancing the client's own desires and expressed desires to participate in certain ways, and how that influences the legal process. The one example that I will give here is we have had several cases at Tahre where we have needed to provide thoughtfully written explanations to a judge, not in immigration proceeding, where we've had to educate the judge about the impacts of trauma and about the VAWA rules, about how we can protect our clients' files. There have been other instances many instances also, where we regularly need to educate the USCIS officers, the immigration judges, even opposing counsel about the impacts of trauma and how that impacts the client in the way that they present, in what they remember, in the documentation they do or don't provide, and how that impacts the rest of the case. So it's a huge balancing act. We all carry it on our shoulders. It's not easy, but know that you have a community at Tahre that will help you through this. And I believe this is where we will finish up before opening up for Q&A again. I will leave you with a special consideration for ethics, which is the unauthorized practice of law. As a reminder, the unauthorized practice of law refers to the application of legal reasoning to facts in order to render advice, prepare pleadings, or advocate for a client at an agency or court. And only licensed attorneys who are in good standing may practice law. There is a special circumstance in the immigration field where a non-lawyer and a non-law student may also practice immigration law while they are at an organization that is specifically recognized by the Department of Justice and where that person has applied for, received, and gone through the appropriate training to become an accredited representative. That's a long process, both for the organization and the individual, but that is a very specific type of accreditation that will grant a non-lawyer the permission to practice immigration law in front of very specific tribunals. I recommend taking a look at the Department of Justice website to make sure that you are fully aware of what it means to be recognized by the DOJ and accredited by the DOJ. Those are two different things. But with those individuals, legal programs must ensure that they provide not just those individuals, but all of their staff with jurisdiction-specific training on the unauthorized practice of law, and that the organization has a process by which to identify and report the unauthorized practice of law. It's hugely important. It puts legal licenses at risk, and we never want to do that. And we want to make sure that we also are maintaining trust in the legal profession among the community members, because when someone who is not licensed to practice law or someone who does not have this accreditation does practice law, it hurts the community, it hurts survivors, and it hurts the trust that lawyers, legal organizations would otherwise have in the community. So hugely important.
All right. As promised previously, we're going to go through questions that have been coming in. Please also feel free to continue to place your questions either in the Q&A or the chat. And also, if you have ideas or things you'd like to share, please feel free to bring those in. I'm also going to ask all of our presenters from today to come on screen so that we can share in answering these questions. So the first one that we have to talk about today is, what are concrete strategies to implement if you become aware that a particular client or case could trigger your own vicarious trauma response?
I think I would say that, as I mentioned during the session, that talk to your team. But before you even talk to your team, identify what is it that's triggering you. Throughout the part of the case, there might be the portion of talking about the incident, declaration writing, uh, particular incident details. What is it that triggering you? Because providing a support to the client is very different than actually focus on each and every fact of the case. If you have identified this case becomes, and this has happened to, our colleagues too, people that we supervise as well. If that happens, then talk to your supervisor. Can this case be, reassigned to someone else because it's triggering you due to past recollection of trauma, or block some time, depending on the trigger, right? If it's so intense that you can't focus on anything, or it's just shaking you up where you need to step out. Remember, I gave an example of where I booked myself 3 clients in a day for 3 declaration. I was done for that day. Not only for that day, but next day as well. So I did not have emotional bandwidth to be able to navigate anything. And it might not be the trauma that's directly impacting you. It might be something that any one of your loved one has suffered and it has now triggered. So understanding where you are at is going to help you decide what you need to do in that. If you need more people to assist you in the case, talk to your supervisors, talk to your peers. If you need to take time off, do that. We are all humans. I think that's really important. Um, that's just my experience, and that's what I wanted to say.
Yeah, I would add, oh, actually, I'll give a second for the interpreters. I would also add the value of therapy especially when you're working with difficult populations or populations that have experienced trauma. It's really helpful to have your own therapist or own support system outside of your colleagues, in addition to your colleagues, for support. And, we have in our office, we have peer support groups that meet every week, and we do staff cases, but we also use it as a time to just support each other emotionally. So, outside of administrative or case staffing meetings, you do have, like Pael said, individual, supervision. But having your own therapist really does make a difference.
Would anyone else want to chime in, or would I move on to the next question? Okay, great. The next question is, do you have any advice on how to identify and remediate situations where the client does feel triggered, spoken for, etc.?
I can start and then I'll invite others in. I think being observant to body language, to how a client is responding, reacting, noticing patterns that a client has, and if they, you know, are not following that same pattern, that's a good signal for me that maybe something has gone off the rails or is different. Um, and then once you identify something's different, I think that same approach that we've been talking about throughout the day around approaching it in a curious, non-judgmental manner, talking about, I observe at the end of our meeting, you usually get up and give me a hug. I noticed you didn't today. Is something different? Um, those sorts of things, just like naming it in a way that lets the client know that you saw it, but you don't know exactly what it is, and stopping yourself from jumping to conclusions and instead getting curious about it and asking can be really helpful. And then, we talk all throughout this presentation about the core of good relationships is trust building. And there's nothing that builds, I think, stronger trust than admitting when we've made a mistake, apologizing for it, taking accountability, and talking through or figuring out ways to avoid that sort of thing in the future. So, having a very human response to our clients that says, I think I had a misstep here. I think I might have spoken for you. Is that what happened? And if so, I apologize. That's not something I should be doing in this relationship. Can go a long way in building trust.
I would like to add to that, in the second part of the question on how to remediate a situation, because it reminded me of a client talking to me about how much she really appreciated her attorney. They went together to the police station to file a report, and there was ongoing questioning. She was re-traumatized and, very triggered about the situation. And so what our attorney did is what Morgan, said. He acknowledged, he observed her responses, her verbal cues, her physical cues, and responded to that. And so in that specific situation, what he did was ask for the questioning and the whole process to stop, remove the client from the trigger and ask for a separate space so that they can regroup, so that she could have a little bit of time and space to regulate, to be validated by the attorney about what had happened and what she was feeling and what she needed at the time. And during my phone call with her, that's all she thought about. Just, being so grateful for the attorney stepping in, acknowledging certain things without her having to say it, and providing that emotional validation and support that she needed at the time. And most importantly, acknowledging the triggers and acknowledging our fault in it if there was a fault in it, like the example I mentioned with the elevator. The team didn't get to ask that question, and so just acknowledging what our part was in it and validating their emotional reactions can be very helpful, and sort of balancing them back again to an emotional state where that they continue the process.
Any other responses? Okay, I think we'll move on to the next question, which is, do you think it would be helpful for us to also plan for the worst case scenarios? For example, if they are detained by ICE after leaving court, what planning should we consider?
We have been working with, and there are various amount of family preparedness resources available, and we can certainly try to highlight some after the presentation. But I think as we are guiding and talking to our clients on how they can create a plan in the event that they are apprehended, or from one day to the next, they are needing to, or they are detained. It allows this type of plan allows for the client to be able to let their support system know what are their responsibilities and what are things at play in their lives that they are responsible for. That being said, that conversation in and of itself can be extremely triggering for a client. So please take that into consideration. The other thing is the fact that, especially if you are an organization that is, that if you are in an attorney's capacity talking about this with the client, it oftentimes may be confusing when they are filling out what could be a family preparedness plan, and they assume that you would be able to take it from there in the event that they are detained. Oftentimes, that can be a problem when, as we have discussed earlier, when we need legal permission and explicit permission from the client to contact anybody outside of themselves. So, as we are also talking about that, it's important that clients also know that we are limited within our scope and what we can assist with, and how we can make sure that their support system knows what to do next in the event that they cannot pick up their child from school, they have a car that they drive, or that they have a job they go to, people rely on them, etc. So that I think that would be other other instances in which we should help clients game plan in that event.
Thank you, Miriam. I also just want to lift up that someone shared in the chat a link to a resource by Public Counsel that's a safety planning tool that Immigrant Legal Resource Center has some family planning tools available in different languages as well. So there's lots of resources out there. We're definitely here to help, and we'd be happy to do one-on-one technical assistance either from Tahre or our partner organization, NVFS, in this. And you can email us at tta@tahre.org for those types of follow-up questions.
I will go on to the next question, and it says, can you speak to advocating for people in detention? Have you at Tahere or or other organizations had experiences with people in detention, and how has that been different in your practice from advocating for non-detained clients?
I can start us off by just answering that, we don't have any sort of program that is focused on detained work. There are other agencies and organizations out there that primarily focus on detained work, and we'd be happy to share links and resources to them. But I think it's inevitable that in this type of work, you at times will have clients that are detained, and that can bring in a whole nother host of challenges, specifically related to logistics, right? You have shorter windows of time to communicate with your clients on attorney preparation phone calls. It can be more difficult to access evidence or to get pieces of evidence from your client because they are detained and can't go and get records released. So there's all sorts of additional challenges at play. But I think the principles that we've been talking about, describing what it's going to be like in as much detail as possible, is even more enhanced in the detained setting. People are having to make really hard decisions about what they're doing for themselves and their families in detention, and having more information about timelines and what the process looks like allows them to make better informed decisions. Is there anything else that others would like to add to that question about the difference between detained work or that aspect? Okay, then I will take us to the next question, which is, do any of you have any advice for trying to be trauma informed towards a pro se adverse party while also advocating for your own client? I work in a family law, and often both parties have trauma, both from their relationship and outside issues.
I can quickly take that. Um, yes, it happens a lot in the family law setting, but it can also happen in the type of cases we see where the client might also be going through the family law setting. And it's also about having the conversation with your client, but it becomes tricky because in your case, it's pro se, but when the other counsel is involved, there is not much you can do. Uh, we utilize the local court system, the judge's instruction. I would say be kind in your responses, and I'm assuming you are. Uh, in your responses, explaining things sometimes help because family law systems are very complicated, although it's set up straightforward. But the forms and the confusion and the hurt, because two parties are involved and the kids are involved, it takes a toll on all the parties. So being transparent and being open to answer any question without taking it personally, I have practiced for very few years, but it's not easy, but it is something that we can do.
Wonderful. Thank you all so much for all of your questions that you have provided. So we just want to thank you all so much for sticking with us for all four parts, listening and engaging with very, very impactful questions. And we just want to help. Thank you so much for everything that you have done to help out the lives of survivors. This will be absolute. I hope that this training will make a difference in the services that we provide to our clients. And as Morgan has mentioned, uh, Tahere is here to help. And there has been the chat, the email listed. So if we need any sort of additional or be a thought partner or help connect you with any of our partners, we're more than happy to. Um, and so our hope is that after today's training, there is a step further into providing compassionate legal representation with trauma-informed services. So thank you all so much for everything that you do on an everyday basis. And then I will pass it off to Morgan.
So here you have a QR code that you can use to sign up for updates from our joint project. We have a quarterly newsletter that is chocked full of links to resources. That's also where you can learn about upcoming webinars or trainings that we're holding, or office hours if you'd like to come and talk with peers about a certain issue that's arising in your practice to get an idea of what others in the field are working on, and to get advice from those of us at the Tahereh Justice Center and NVFS. Um, we're also always happy to answer questions offline. And if you sign up for our materials, we will also be sharing with you the slides from today, as well as our trauma-informed manual. You should now have in the chat the link to how you can ask for technical assistance from our project as well. So feel free to use that. We at Tahereh and Northern Virginia Family Services just want to thank the Office of Violence Against Women again for their support in this project that made today possible, and encourage you to follow the links and stay in touch on any questions you may have. Thank you and have a wonderful rest of your day.